Hi, I'm Samuel Doncaster. I'm the owner and founder of Fraud Fighters Law Firm, and I want to talk to you today about a question that I got from another experienced real estate lawyer that relates specifically to fraudulent non-disclosure in a residential real estate transaction. And that question is, how can you possibly get somebody relief if the person who screwed them is broke? Specifically, how can you completely unwind a transaction if the person who screwed them is broke? And I have a way to do this. The short version is you need to be really good at real estate law. So for starters, you do need to have a good case of underlying fraud. And the way you know that if you've bought property is if you've been sincerely surprised at its condition, if you've gotten a massive repair bill, if you've discovered mold or water penetration or a roof leak, and you didn't expect that when you bought the house, you probably have a good claim and you should talk to a lawyer about that. One of the toughest situations that a lot of other real estate lawyers don't know how to handle is how to protect your client when the person who cheated them is broke or has already disposed of all the money. And to be clear, when I talk about helping you, I mean getting you money so that you can get out of the house and move into a nicer house or get the house you're in repaired. But the big thing we're going to be doing is putting money in your hand so that you can be living in the kind of place that you deserve. Now, the way we do that is first and foremost, we bring a claim against the seller. And when the seller claims that they are broke, we go back to the settlement statement from their escrow file and point out all the money they took out of the transaction. And in current market environments, that's often well into the six figures. And if they're claiming to be broke, we start just by asking, where did those hundreds of thousands of dollars go? And the truth is, by the way, almost always the answer is it went into a new house, and a less experienced real estate lawyer very gleefully thinks that that can be protected from collection. And so what I do then is I say, well, turns out because this was a fraud, my client's entitled to a lien on any property built with the proceeds of the transaction or any property purchased with the proceeds of the transaction. And so then I get to tell that liar that we're going after their house and we're going to seek a lien on it. And we're ultimately going to be going into court asking for an order that we can take that money straight out of the house that you bought with the proceeds of that fraud. And by the way, 9 times out of 10, that works, right? 9 times out of 10, the seller who cheated somebody when they were selling a house rolls the money into their next house. It's right there, safe and sound, as long as you have a lawyer who knows how to get it. Now, I may be making that sound really simple, and the reason for that is it's simple for me. But if you have this kind of a problem, what you really want is you want to make sure that you are hiring a lawyer who knows how to do this, who has brought these types of cases before. Keep in mind, right, I started this by saying this is a question I got not from a consumer or a client. This is a question I got from an experienced real estate lawyer who's just not as focused on disclosure fraud as I am. So if you've been cheated in a real estate deal, if you've been cheated in the purchase of residential real estate in Arizona, give me a call, 480-666-4054. We can set you up for a free appointment.